The other big story we've been tracking, the High Court denying Mr P Chidambaram, the former finance minister, anticipatory bail in the INX Media case. It said that it's preposterous to say prosecution of Mr Chidambaram is baseless, politically motivated and an act of vendetta. The court has also said that the facts of the case reveal prima facie that the petitioner is the kingpin in the case. A little while earlier on, I spoke to the senior Congress leader, Dr Abhishek Singhvi. Well, joining us now, Dr Abhishek Singhvi, for his reactions on what has happened today. Dr Singhvi, this is obviously not an order, but the remarks made by the Delhi High Court, very, very strong, referring to Mr P Chidambaram in the strongest terms, saying that he is the king, he is the linchpin in this entire allegation of corruption. Your response to this?
Vishnu, it's important to step back from the sensationalism and appreciate a few basic facts. First of all, linchpin or kingpin are obviously adjectives which are part of allegations. Only a trial decides. In a bail or a rejection of bail, they have no real meaning. But most important in a bail, you have to remember that the sole time Mr Chidambaram is called by the CBI, sole is 6th of June 18, and he went. He is called by ED about 8 or 7 times. He goes each time. Total hours quizzed in these 10-12 times is 50 hours plus. He is on bail for 15 months. This very order is reserved, that means heard in January and delivered today. When we asked for a deferment of the order by 1 week, the learned judge decided that deferment request, do you know at what time? 4:05 or 4 o'clock. So obviously we had to rush to the court. The Supreme Court simply said, you approach the senior most judge tomorrow for mentioning. Now, tomorrow Chidambaram will approach the Supreme Court. One way or the other, he will get or not get released.
There is a very strong possibility that he may still be arrested. Is that a concern for you presently? There was a CBI team at his residence. He wasn't there at his house. Is that something that's a strong possibility?
Of course he can be. Just a minute. Let me be very clear. Of course he can be arrested. Then CBI has to live with its conscience to explain to the public and the court that A, he's a flight risk between now and tomorrow. Not been a flight risk for last years. It's a 0708 offence. He's tampering with documents of 0708. All statements, charge sheets have been recorded from 16, 17, 18, 19. He's not cooperating after attending every summons. The CBI summons is only one, ED is 7-8. So yes, if the CBI or the ED thinks that between today and 10:30 tomorrow when he can approach the Supreme Court, this is a terrible, terrible risk, then yes, they'll arrest him. But sir, then you will have to consider whether it's persecution or prosecution.
The Congress and Mr Chidambaram have argued that this is all politically motivated. But in the observation of the High Court, they've said it's preposterous to say the prosecution of Mr Chidambaram is baseless, politically motivated and an act of vendetta. So they seem to be ruling that out of the equation, irrespective of whether he's found guilty or not. It's a strong remark.
Look. A bail application remarks which we believe are erroneous, which is why we are appealing. Why would we be appealing if we accepted the order? Secondly, a bail application remark has no bearing on the final trial. You know that what is said in a bail rejection or acceptance is explicitly by law of no relevance to the final trial. People denied bail can be acquitted completely. So don't go by these adjectives, and this is not the final court, it will be challenged. Ultimately, yes, whether tomorrow or a week later, the Supreme Court will decide.
But do you allege still, sir, that this is political vendetta? Is this what you still allege, that this is political vendetta?
I choose my words carefully. I choose my words carefully and categorically. With the cumulative facts I have given you, if you add them up, you decide for yourself.
No, sir, I'm asking you, sir. I'm not going to say anything. I am asking you whether.
No, obviously it is persecution.
Okay, it is persecution by this government, by the CBI. Obviously. That's your allegation.
Because none of the triple tests are satisfied. The matter is old. He can be tried, he can be convicted, he can be subjected to criminal process, interrogation, but there are no probable cause for arrest. We are talking only of arrest. Nobody is saying there is innocent. Nobody is saying he is guilty. Decide it. Question is there probable cause for arrest?
Sir, the court has also said simply because he is an MP would not justify grant of pre-arrest bail to him. It cannot be forgotten that the petitioner was the finance minister at the relevant time. He had given FDI clearances. Now you can say that this is not an order.
I don't think I appeared
But sir, I'm just trying to understand that these remarks, sir, and I know that they are not valid in terms of an order, but the fact is they have been made. What does this point towards? A belief that the allegations are serious?
Vishnu, please hear me. Please hear me. Mr. Chidambaram, I was the counsel for him in one matter. Sibbal was the counsel in the other matter. None of us ever argued that he should be granted PRS bail because he's an MP. I don't know where you're getting it from. No one has argued that. How can you argue that an MP is not liable for pre-arrest?
No, I'm not arguing that. I'm saying this is what the court has said in its observations.
Well, it's obviously wrong because this is not the case set up by Mr. Chidambaram. We point out a single ground which is taken that there is no immunity for MPs.
The larger one final question, because I know you have to go, just in terms of the allegations itself, the involvement, the alleged involvement of P Chidambaram, who allegedly got some sort of a kickback which was done in the INX Media deal through his father, who allowed this entire deal to go through. Why do you believe that that was not the case at all? Why do you believe that the primary allegations themselves are wrong?
That is not for you or me to judge today. In fact, P Chidambaram is both on bail and not convicted. But since you asked me a question, I'll give you a teaser in terms of a sketch. The allegation is about a collective decision of a FIPB headed by Chidambaram. The FIPB consists of 5 eminent secretaries of the Government of India, one of whom Subbarao later became Governor of RBI. All that Chidambaram did was to endorse the decision of these 5. Now, if that collectivity can be said to be a kingpin, well then I don't know what kind of evaluation you are doing. It was an institutional decision. You can bribe one person, 2 persons, all 5 along with Chidambaram. There is no demand of money. There is no money flow shown in terms of a nexus with this thing.
Okay.
If Mr. Karti was persuaded to get this decision, how were these 5 wise people persuaded? Secretaries of the Government of India, one RBI governor later.
All right. Okay, so a couple of points mentioned over there, points which would perhaps appear in Mr. Chidambaram's defense as and when it's time for him to defend his case in the Supreme Court. But the big key is now going to the Supreme Court and what the court ultimately has to hear, whether they're going to actually accept his petition for his bail case, whether they'll grant it to him or not, anticipatory bail. It's been rejected by the High Court. What will happen in the Supreme Court? We'll find out more about that tomorrow morning. Dr. Abhishek Singhvi, the lawyer for P Chidambaram, one among a host of lawyers over there, speaking to us in that exclusive interview. Well, what exactly is going to go on in this case? What is it all about? And how is this actually a tough day for the Congress party, to say the least, with Ratul Puri, the nephew of the Madhya Pradesh Chief Minister Kamal Nath, also having been arrested. We are looking at all of this today. Joining us now, Vivek Reddy of the BJP, Tehseen Poonawalla as well. We'll also be joined by the Senior Advocate of the Supreme Court, Vikas Singh, in a little while from now. Tehseen, yes, I know, and we've discussed this, that these are just observations of the court, but would you not agree that given the nature of these observations, it points to a very serious case?
No, absolutely not, because
it's not a serious case.
It absolutely points to no serious case, because the case will ultimately go on in a trial court. You will appreciate it in the High Court. The defendant does not put his defense of the accusation in front. Therefore, these are observations of the court. There have been many instances where a High Court has refused bail, but the Higher Court, the Supreme Court,
an observation which has resulted in no anticipatory bail being granted.
And there have been many instances. So tomorrow he may get it in the Supreme Court, and this does not affect the trial. In fact, in 2G, for example, where the Supreme Court made some observations and people actually went to jail, the trial court acquitted everybody. So there's no connection. But I just want to make one very important point. Please appreciate and explain to me one thing. Irrespective, you agree, I agree that this is not a trial. Chidambaram's moving Supreme Court tomorrow. What is the tearing hurry to arrest a man tonight on humiliating?
But he's not been arrested. Is that what you're sure that's going to happen?
Why did the CBI and the ED go? They could just serve summons. Why did they go there?
Maybe they'd gone to serve summons.
Do
you believe he might be arrested tonight? Let me ask you that.
I think that is where I think Vendetta comes in. Of course, there's a possibility, but I do believe that tomorrow he's moving Supreme Court. Give summons. But in a case which is 2007, 2008, where a man has not, where a charge sheet has been filed, why would you want to humiliate somebody? This is the vendetta of Narendra Modi, which is actually coming through.
I just want to go, before I go across to Mr. Reddy, I want to go across to Mr. Vikas Singh as well. Sir, the point that's repeatedly mentioned is that is that, look, these are just observations, but can one read into these observations to get an idea of the seriousness of the case? Because what said is that the facts persuade me to decline pre-arrest bail to petitioner. The facts of the case prima facie reveal that the petitioner is the kingpin, the key conspirator in this case. It's a classic case of money laundering. The twin factors which are weighed to deny pre-arrest bail to petitioner are gravity of offence and evasive replies of the petitioner. You know, and these observations go on and on. To you, sir, as a lawyer, does this not indicate a very, very serious set of allegations?
Well, according to me, the stage at which these kind of allegations are being made is really irrelevant, because you are still he's still an accused. And if you will recall, the Criminal Procedure Code till 1970 didn't have an anticipatory bail provision. The 41st Law Commission felt that people in political, opponents may misuse the arrest power, and that is why the CRPC was amended and the anticipatory bail was provided. Now, if you want to arrest somebody like Mr. Chidambaram, you have to appreciate three things. I am not in his defense. I don't know what is his, what are allegations against him, and I am not. If he's done something wrong, he definitely should go behind bars. But for the purpose of anticipatory bail, there are only three considerations. One is that whether the person will abscond. The other is whether he will interfere with the investigation. And the third is that how will you secure that his presence in the trial of the matter. Now, none of these cases apply in the case of Mr. Chidambaram. The reason given that he is given evasive reply, now that is his fundamental right under Article 20 subclause 3 of the Constitution of India. Article 23 says that if you are accused of an offence, you can't be compelled to be a witness against yourself. So if you don't reply to an answer, that could be, and the trial goes on, that could be a circumstantial evidence where the court may take a adverse view against you, or an adverse inference that you failed to reply to a particular question. But you can't compel anybody to. So actually in this country, criminal jurisprudence is completely going for a 6. People don't realize that there is a presumption of innocence till the conviction takes place.
Would you say that's because there's a sense that there's a presumption of guilt almost in some cases?
When the judge is going to retire in a couple of days.
Yeah. No, very important points. I wanted to go across.
No, it can't be. That's not the law. That's
I know, but do you
land.
believe that that's what it almost seems that way, right?
And it will be a Vishnu, only one last thing. It will be a huge coincidence if the judge who is retiring in a couple of days gets appointed to some important commission or tribunal immediately after retirement. That will be a huge coincidence.
All right. That's a fairly strong remark over there. I want to go across to Vivek. The 3 points mentioned by Vivek Singh. Abscond. Was there a danger that Mr. Chidambaram was going to run away from the law? Interference. Was there a fear that he was going to interfere in the process of law? And securing the presence of Mr. Chidambaram, would this have been impossible for investigators, for the police, for the CBI? On all of these 3 grounds, some would argue that no. So if this was the case, then why was there this effort to potentially arrest him today? Was that not vendetta?
Vishnu, I think yes, Vishnu, I think it is not just these 3 considerations. If the panelists say that these are the 3 considerations on which bail must be granted, I don't think this is the right way of understanding the things. First of all, you look at the magnitude of the offence. Suppose a person commits a murder, it is not treated as a case similar to a trespass or a case similar to assault. It is treated differently. You look at the magnitude of the offence and then decide whether the person must be apprehended or not, and whether he is required for investigation or not. Now, in economic offences like this, where the court feels, the court is entitled to prima facie look into the material, and the court feels that look at the magnitude of material that is available against Mr. Chidambaram, and that he is the kingpin and he has a prime role in the conspiracy.
But
these are the observations.
Let me just ask you.
Can you just leave these observations? Can you just neglect this material?
Just one sec. Vivek.
So therefore, in economic offences, let me just complete, Vishnu. In these economic offences, definitely he is required for investigation. he is required to be arrested, and he is required to be treated as every other
Vivek, let
individual.
me ask you a question.
That's
it
the
pertains
sad
to a
story in our
certain graphic
country.
that we've
as
got
soon as
on
one
our
is an
screen.
MP, one is a great lawyer,
How
they
is
say,
it that
please
there are
leave him,
only
he's a VIP.
3 cases against NDA leaders presently being looked at? The Reddy brothers, Kuldeep Singh Sengar, and one other case, and Shivraj Singh Chauhan, and there are about 20 plus cases, more than that, which are being looked at against opposition leaders. Is this not vendetta? This is a fact. These numbers are a fact. These cases
That is
are a
because
fact.
10 years they looted the country.
So the fact
Correct,
that
Vishnu. That is because 10 years the UPA looted this country. That is why there are so many cases against UPA. We were not there, and did we ask them to loot India?
okay, Mr.
That
Vikas
is what
Singh,
they have
come
done.
in, yeah.
I mean, he sits as a finance minister, and his son has all these remittances. that
Okay,
is
one
coming
moment.
into him.
Tehseen has a
Where is
point.
it
Yeah.
coming from?
Tehseen,
These
go ahead.
hundreds of crores.
All right.
Yes.
Mr. Reddy conveniently forgets that when you are in the opposition, like Ms. Mukul Roy, Himanta Biswa Sharma, you are then corrupt or filth as the word used by BJP leader for them. But when you join the BJP, no investigation happens on you. He clearly forgets Pema Khendu, where the investigating agents, where the agency caught him at 1.8 crore cash, the late Sushma Swaraj in Lalit Modi case, or Dushyant Raje, or Shivraj Singh Chauhan, whose name was dropped from an CBI investigation. I don't want to get into this. Now Mr. Reddy out here says, look, there has to be a greater than these three, these three
Shouldn't
causes
there
to.
be-
Please, sir, I
why
never
are you
interrupted you.
defending
Give me
another
the respect I
Vivek,
give you.
one
That
second. Vivek, half a
Chidambaram
second.
should
You
be
have
given
to
a
not.
bail.
You have to not
Vivek,
interrupt
one
me.
second.
Please focus on this.
Vivek, 1 second. Go ahead.
I will focus on what the anchor asks me, not what you ask me. Now let's come to the point. The jurisprudence, Mr. Vikas Singh is absolutely right. Is your bail, not jail. You're innocent until proven guilty. In no trial court has Mr. Chidambaram been arrested. Now, say Mr. Chidambaram escape. He's attended every single summon. The charge sheet is filed. All evidences have been submitted on the basis of which the High Court made those observations. He's not contested it. The case is of 2007. There is no way he can destroy evidence. Tomorrow morning he's coming before Supreme Court. Why do you want to humiliate somebody by arresting the person tonight? Is it punishment? It's not punishment by arresting him tonight for the crime.
It is not
so what
a
is the
question of humiliation.
Except for domination
Please.
and ego. What is it? Give me a legal point.
All right.
You
Well,
are-
we'll figure out what the legal point is when
Can
this
I come
comes
in,
up
Vishnu?
at about
Can
10:30
I come
tomorrow.
in,
I'm
Vishnu?
out of time, Vivek. Just 30 seconds. Yes, go ahead. 30
Vishnu,
seconds. Yes.
this is not a question of humiliation at all. Yes, this is not a question of humiliation at all.
Okay, not a
this is the
question
way
of
you understand
humiliation.
criminal
I think the
jurisprudence.
larger
I'm
issue
very sorry.
of whether the Supreme Court
it is
agrees
a question
to
of
hear
what you
the
did to
anticipatory
backstab
bail
this nation
application
and
or
loot
not
this nation.
is something that
So you
needs
got to
look-
face the law.
One moment. Let him face the law. He's not saying that he's not going to. One way or the other, we will know tomorrow. Will anticipatory bail be granted, or will the Supreme Court agree with what the High Court judge has said and say that no, there is no ground for anticipatory bail, which paves the way for arrest in this case. I'd like to thank all of you very much for joining us.